everyone. My name is Guy Blake, and I am a partner at Davis, Shapiro, Jewett, Grable, Levin, Granderson, and they couldn't fit it all on this. I started my career, I went to law school at Pepperdine in Los Angeles, and was going to go into real estate law at the time, and was lucky enough to fall into an internship at Warren Chappell. I was hired by Ed Pearson, who was also on the panel. Warren Chappell was a division of Warner Brothers Music at the time, was a music publishing company, and they owned copyrights, songwriters, and fell into the entertainment business by accident that way, but loved the intellectual property elements of it, and immediately it clicked for me. I was lucky enough to stay at Warren Chappell throughout law school, and after 10 years, I left Warren Chappell and joined my current law firm, and I've been at my current law firm for another 10 years. Oh my God, that means I'm the crack seat. At my current law firm, we primarily represent talent. It was originally founded as a music law firm, and to this day is about 60–70% music. We represent clients like Lumineers, Now Black, Dio, Ludacris, Linkin Park. The list goes on. And I have some television clients. I represent Wrestling League and a couple of different production companies in the television world and reality TV world, as well as talent in those various areas. We also represent some sports figures, not in a sporting capacity, not in terms of we don't practice sports law. We don't negotiate their collective bargaining agreements. We handle them as celebrities. So we handle their deals like their endorsement deals and their various deals that they would have that almost any celebrity of that stature would have. I went to the University of Oregon, which is why I've come here today. This is kind of my way of giving back to the university.
My name is Joe Barney, and I'm with the short law firm Lee and Hayes. We're based in Spokane, Washington. We have some offices across the country. I fairly recently joined with Lee and Hayes. 20 years ago, so you started practicing, and 20 years ago I was still watching cartoons. So with that perspective a little bit, I have been in business for a long time, but I feel like I've been growing employees for improving intellectual property. I started my first band when I was 12, and dealt with copyright issues that way until I was in my early 20s. I gave that up to go into business. After that, I worked as a creative works manager for a long run of radio stations, and so I oversaw all of the development and acquisition. And I dealt with radio talent, although I don't know, sometimes I don't really consider radio talent, but that's how they wanted us to refer them as talent. So I left that. I went to law school in Ontario for the purpose of practicing IP. And while I was there, I was doing research on the effect of, and this was for my own personal edification, the effect of declaratory judgments and cease and desist letters in the wake of the Benjamin decision. I don't know if anybody remembers that, but I was in law school at that time. I thought, how fascinating is this? And as I was doing that research, I came across a demand letter that a company called the Coalition to Advance the Protection of Sports Logos had sent. And as I delved more into that, I realized that they were based in Coeur d'Alene, which was just 45 minutes from where I live. So I called them up one day and I said, hey, I read this, I found this online, there's this new decision out, and I think that based on this letter that I'm reading and this new Supreme Court decision, there's a good chance that you're going to get a declaratory judgment action filed against you. And they gave me a job. That was kind of a great, that was my great start. So the Coalition of Advanced Sports Logos is made up of all the professional sports leagues, NBA, NFL, NHL, Major League Baseball, It used to also involve the Major League Soccer. Major League Soccer, but we also work with some other large international sports clients, and we would do almost exclusively trademark and copyright enforcement, as long as whatever it was, whatever the infringement was, or whatever enforcement needed enforcing, dealt with more than one of the sports teams. So there was multiple organizations. We would coordinate that effort. We didn't ever do any litigation. We would handle everything creatively up until the point where, okay, if they needed litigation, then we would work with outside counsel to make sure that those things got litigated. So that was a really interesting experience. I did that for about 3 years. And then after that, I started my own intellectual property law firm, again in Spokane. That lasted for about a year. And then the firm that I'm at now, they were developing a soft IP group. And so we and Hayes is known as a very well-known patent law firm. And so they decided they wanted to look at what they're doing, and I'm kind of one of the trademark guys in Spokane. They said, why don't you come join us? And so it's been really interesting to bring in this sort of the soft IP, and I don't say soft IP in a derogatory statement like Cat kind of said, I'm bringing in kind of their knowledge of technology and the innovation that comes with that, and combining that with my passion for copyright and trademarking. We've been able to create a really interesting and fascinating and what I consider to be a very aggressive soft IP practice that involves entertainment and sports clients. So Nick Biger interviewed at our firm. That's how we found out about me. So shout out to Nick. There he is. Thanks for having me today.
No problem. My name is Ed Pearson. I'm a solo practice lawyer in Seattle. Many years ago, I was a first-year law student and didn't quite know how I was going to fit in as a lawyer. And I also had this big crush on Stevie Nicks. And so instead of studying the short casebook that I was supposed to be studying, I went to a Fleetwood Mac concert. I saw Stevie Nicks on the side of the stage before they went on. This is like early. This is like the very first White Album. It's called with Stevie and Lindsay joined the band. And I saw her with her arm around this guy with a three-piece suit, and I thought, oh my gosh, I could be that guy. And it was enough. It was ridiculous. It turned out that wasn't the lawyer, but it was enough to fuel me through a couple of years of trying to figure out how do I become a music lawyer. And really, that's what I became, and that's all I've done for a long, long time. So I've sort of had three phases of my career. And the first was in Colorado. I opened up a practice there and represented musicians and photographers and tried to do a broad-based entertainment practice there, and did it for close to a decade. Then I got a job offer from a company, One Shop Music, went there in 1989 and worked there for a long time. As Guy mentioned, we worked together for many years, and we were there in what I call the crazy glory years of the music business, when we were spending money hand over fist, and it was kind of a wild time, and really a good time to be right in the center of the music business. Lo and behold, in comes the digital era, and everything changes and turns upside down, and we all end up in different places. And so I knew I never was destined for Los Angeles. I always thought I might move back to Colorado, and then I sort of started to appreciate and come to love the Pacific Northwest. So I looked at Portland, I looked at Seattle, decided to move to Seattle. Did it about 4 years ago, and again hung up a shingle after many years. And so there, I just wanted to do music. That's what I do, and that's what I felt I could do. And it's kind of crazy in this day and age, particularly to try to just do music. But I had a good fortune getting some good clients. So right now I represent, I got one company client. I recently work for the Discovery Channel, music things. But otherwise, the client keeps me busy most of the time these days. Is a client knocking on Ryan Lewis that I had the good fortune to represent for a few years. And I also represent the head and the heart of the bank called the President of the United States of America. So I've got it's a small practice. I've probably got about 10 clients, but I guess for me, I'm living the dream. It's the dream I always wanted. And I never even met Stevie Nicks, but I think I'm better off for it.
Well, Ed totally has the practice that I wanted. I I gained immediate street cred with my 13-year-old when I told him I was sitting on a panel today with McElmore's lawyer. So I'm going to take that to the bank. My name is Mike Cohen. I'm a shareholder at Schwab Williams and Wyatt here in town, so I'm representing Portland. Also a proud grad of U Law School. And my long and winding road to getting where I am now started back in the music industry. I was a concert promoter, talent buyer for several years. Did all the hippie rock shows, the Grateful Dead shows, the Bob Dylan shows. It was a Jimmy Buffett show. Actually, it is the ultimate moment that caused me to take a different path and ultimately go to law school. I had to spend hours and hours in a back room with a fellow who was affectionately referred to in the music industry, the touring industry at the time, as Dune, who was Jimmy Buffett's tour accountant, who basically arranged me a new one for about 15 hours straight trying to sell that show, and I finally decided I wasn't getting paid enough to put up with that kind of grief, and decided to take a different path. So took the LSATs, went to U of O ultimately, but I always knew going to law school that I wanted to have entertainment in general and music in particular be a part of my practice, and so I really, focused a little bit in law school, but obviously coming out of law school even more so on intellectual property, and that's really what my practice I would fairly characterize it as being now is really a diagonal intellectual property practice as opposed to an entertainment practice in particular. I do have entertainment clients that I work with, and I love working in that arena, and I do it as much as I can. But the fact of the matter is my practice has kind of blossomed into more than that, and I do a lot of patent enforcement, trademark enforcement, copyright enforcement work for a lot of companies. I do represent some individual entertainers in negotiating their deals. Also some other kind of Portland-centric celebrities in various situations. But the entertainment stuff is really something that I'm still passionate about, and I do it as much as I possibly can. One of the neat things about Schwab as a firm was when I joined them, and still are, they really encourage their young lawyers to be entrepreneurial and try to make their own way and develop their own practice at a very early stage. So they were very supportive in giving me a budget to work with. There was a partner at the firm who was very good friends with Beverly Hills entertainment lawyer who I flew down and had lunch with, and that lunch ultimately blossomed into us getting involved in what wound up being about 6 years of class action litigation representing recording artists against Capitol Records initially, and then against Universal Music Group after that. So it's one of those things where you just kind of never know what the connections are that are going to lead you down the path that you wind up following and getting to where you ultimately want to go. But this kind of an opportunity to kind of hear the perspective that we each in very different ways got to where we are, I think it's hopefully going to be helpful to you as students in figuring out what directions you want to go.
Thank you very much. The first question on my paper is, what steps did you take to get to your current position representing athletes, celebrities, and IP owners? I think we've covered that.
Yeah.
So thank you very much for coming. Good night. The title of this panel is very broad in the sense of the title is representing essentially entertainers and athletes. So in my mind, when I read that title, it meant 100 different things. I'm sure in your heads it also represented 100 different things. We didn't quite know what we were going to talk about. In fact, until about an hour ago, I didn't know what we were going to talk about. But I got to thinking that with this audience, it seems to me that you've probably never been exposed to the raw underbelly of what it really is like representing clients and getting clients in the entertainment and sports worlds. And so one of the things that we talked about doing was really just kind of going in and talking to you guys about what it's really like out there and how it's done. Not that we necessarily know all the answers, but at least how we do it. And so I wanted to kind of throw that subject out into this panel. One of the questions I'd like to know is, let's talk a little bit about team building. Who are the key players in your lives? We'll start with you. Who are the key players in your lives that you look to today, or in your legal history, to get the clients, to get where you are today? What are the tactics you've used, or you don't have to name necessarily, but what are the type of people you use to get here?
Yeah, sure. I'll name a few of them. The person, frankly, who was always yakking in my ear to go to law school back when I was in the concert business actually wound up being somebody who worked here for the Trailblazers for many years. It's a fellow by the name of Jay Isaac. He at the time was a kind of reformed lawyer. He'd already gone out of half being a lawyer, decided it wasn't his thing, and had become an artist manager at the time, so we shared office space with him. And he was the guy literally, it was every day he'd come into my office and you should stop this, you should go to law school. And ultimately that's kind of what rang true and pushed me down the path that I did. Jay in particular has been a great resource for me throughout the years. Not only convinced me to go to law school in the first place, but has been a great referral source. And in addition to that, you know, there are just a lot of folks who, back when I was buying concerts as a professional talent buyer, who have been very helpful in sending clients to me. I did some work for the hippie rock band Fish, and that was on the strength of the fact that I used to book them and had become very close friends with their personal manager. And when they needed some trademark and counterfeiting, anti-counterfeiting work done to them, I was their first call. I did some Green Day work when they got sued here in Oregon, and that was as a result of, as a matter of fact, the lawyer who was on the opposing side, who was representing Capitol Records in that class action lawsuit, who he and I wound up still maintaining a great rapport and friendship, even though we were on opposite sides in that case. So it can come from anywhere. It can come from lawyers that you're adversely opposed to in a particular matter. It can come from some of the most unexpected places. But I will say that some of the managers and talent agents that I had the benefit of getting to know and work with a lot when I was in the concert industry have continued to be very good referral sources for me when issues come up in Oregon and Washington. You know, the fact of the matter is, if you want to be a guide in the whole entertainment lawyer, it's a tough thing to do. In Portland in particular, it's a little bit better of a market up in Seattle, especially if you are lucky enough to cross paths with somebody as awesome as Macklemore. But you know, in a tertiary market like this, it's pretty tough. So you have to really be open to taking what sometimes are kind of those one-off opportunities. It's not every day that Green Day gets sued in Oregon, but it was nice to be the one that got that call when it happened. So.
Yeah, I would concur about, especially the manager connection, when it comes to the talent and musical talent, acting talent, and athletes as well. I find that the managers are a critical connection for me, that maintaining those relationships. It seems that the managers are really the hub of the business. They're the ones who the clients look to for everything from what lawyer should I use to what accounting firm should I use, where should I live, all of those pieces of advice. So being in that manager's head at the time that you've got a client who's considering hiring a new lawyer is going to be critical in my experience. Anyway, when it comes from the talent side of things. But Retta, I'm curious from your perspective, because you have a practice that represents a lot of corporate clients, what's your magic tip? Who do you look to?
The interesting thing with the corporate clients is it's typically they don't have any one person in particular. So unless you have like a friendly relationship, like the partner of your firm, went to law school with the chief CEO of one of these corporations or something like that, you essentially just have to prove that you can do that. So in the litigation sense, it's saying, look, here's our portfolio, here's our people, this is why we think we're the best. There's kind of the cajoling that happens there. It's a really interesting thing because up until now, someone used on the previous panel this idea of Wild West, and my perception of client development prior to joining me in Hayes has been this Wild West kind of you go to conferences and you're just in the places where these people are and they see you and there's some name recognition and you just do good things. That shifted a little bit because we have actually a team of people that we call our solutions group that they help me do my client development. So a lot of firms have client development helpers, but this is a team of people that is devoted to analytics and statistics, and I guess it's a patent firm, so everything is very scientifically based, but they help the attorneys position themselves in such a way that not only are we presenting really useful information to people beforehand, like, for example, there are 37% of all cases in the USPTO that deal with primarily using similar marks in this particular region or this particular industry or this particular whatever. This is the outcome of that. And we know that because we have statistics based on this, and therefore we're going to give you this advice. We're going to tell you that you have a 40% chance of losing, so, is that where you want to invest your money? And so a lot less Wild West, and it's much more analytical and engineering-based kind of, and I like that. In terms of what I do, I try hard to build a good rapport. I think that there's nothing of substitute for taking a client out to lunch, giving him face time, and doing a good job. And I think, the more seasoned attorney might agree with that. Sure, you can work the greatest firm ever, or you can be a solo practitioner. But it's just the delivery of whatever service.
I'm going to actually get into an area that you guys have probably never really even contemplated right now, which is not just getting the clients, but how do you keep the clients? And I think Ed might be a good one to talk about this, because right now you've got a very high-profile client that everybody's gunning for. All the lawyers out there trying to steal your client. How do you do client maintenance? How do you play D, if you will, on those kinds of things?
Well, a couple of thoughts and things on that. Early on, when my client, back when I went down to Los Angeles for some big showcases, I happened to be in Los Angeles around the same time, so I went there, and I was backstage at this show, and he hadn't gone on yet. And I look, and I see somebody out of the corner of my eye, and I think I know that person, and then suddenly the light bulb goes off. That is a lawyer, a big Century City law firm. He's come to take my client. And so I literally positioned myself between him and the door of my client and talked to him the whole time and didn't let him in. So it's sort of kind of a body block, would be the sort of self-help way to do it. But I think, but more than that, I think it becomes, being an entertainer, I can only speak on the entertainer side, and music in particular, but being a music lawyer, being an entertainment lawyer today is quite a bit different than it was a couple of decades ago or a decade ago. And there was a moment in time where it was all about doing record deals. It was about doing record deals and publishing deals, and your world was paper and 10 drafts here and 10 drafts there and so forth. And there was a certain timeline to it, right? You would put things in the fax machine, and then, it would take you 6 weeks or 6 months to negotiate a deal, and that was it. We're in this world now where everything tends to be fairly instantaneous, or many things do. So I think that, going to your question, Guy, I think one of the things that you have to do as an entertainment lawyer today is be, if not instantaneous, at least able to respond on a same-day basis. The guy I used to work for, a lawyer named John Biederman, a great legendary lawyer, who taught us, I think, both how to draft contracts, which becomes an important component of all of this. And he used to call the legal department Don's Dry Cleaners, in by 10, out by 4. And there's something to be said for that, especially today. And I think we all have that, be it your partner or be it your mother or whomever. They send you an email and they wait 5 seconds and they don't know why you haven't responded. Well, in some respects, your clients can be like that, especially when we're talking about things like their career. So I think that the ability to be able to be immediately responsive to their needs in terms of addressing issues, some of which may be legal, some of which may be business, some of which may be therapy, become pretty important, especially early on. And I guess the other thing that I find in that process is kind of being the early one to the process. Hopefully, with the right client makes the big difference so that they stick with you. I look at long-term relationships in entertainment, and I find that the good ones, the ones that I have the most respect for on both sides, are the ones that have lasted decades. And part of it is you were there at the beginning, you grew with me, we grew together, we went through all these battles together, and then there will be the Johnny-come-latelys who will kind of come in and try to raid it, or say, I could do better, and so on and so forth. And I think that, let me just go one step back on that. Also, I think it's finding the right people. I have, I guess, the luxury at my point in my career, in my life, to kind of go, you know what, it's not for me. I don't really want to, I have to like the music. I have to think there's something going on with the artist, and I actually have to like the person. And so, you talked about the team and who is it, I'm a solo practice lawyer. So I rely on my dog to suss things out. I've got my dog, I have my dog, I pulled up my business card, because this wacky business card with my dog on it. And it sort of becomes the sort of telltale. And it's like, how the person reacts to my dog is going to tell me how they're going to react 3 years from now. And it's just,
He's not kidding, the dog's on the table.
What's that?
The dog's on
The
the
dog's
table.
on the table right now. Yeah. The dog's always with me. The dog's in every meeting. First time McEnroe gave me the dog. It's like, McEnroe likes dogs, Ryan likes them, hey, this feels good to me, right? So it's sustainable. So I think, but it's that combination of things. You have to deal with the right people. I mean, there's certain people, it's like, great, you're the Portland lawyer, I'm the Seattle lawyer, you take me to this step, and then I'll go to, get the big lawyer, and then get me the $20 million deal, if that's what they want. But if that's what they want, you just kind of hopefully over time suss that out. And so you're dealing with people that want to stay with you because, and we'll talk about this later in the panel, you probably have represented them for a fair period of time for no money or very little money, or certainly not your hourly wage.
One of the reasons why I bring that up is because geographically, you all in Portland or in the Northwest are going to be experiencing that. If you're playing in this entertainment world, whether you're representing corporations or talent, you're going to have the big Hollywood lawyers, the big New York lawyers coming after your clients as soon as they raise above the radar. You're really you have to be aware of that and get out ahead of that. From a corporate standpoint, how would you address that? How do you, I know corporate clients aren't as subject to the whims of talent clients, but I know they are subject to money issues. And the first thing they'll look at when numbers go bad is who do we fire? We'll fire the others. Yeah, we'll fire lawyers. How do you deal with that from a billing standpoint? How do you manage those relationships to keep them come back?
Yeah, that's a tough question. It's very client specific, and it has a lot to do with what relationship you develop with that client. Not so much different from the individual guy. Oftentimes on the corporate side, you're not figured out representing them maybe for free, but you're talking about continuing to do the same amount of work you've done, but at a reduced rate. And some of the larger corporate clients just demand it. And if you want to work with them, then you'll work with the rates that they are willing to pay. It's tough. I don't have a very good answer.
Well, it's not a better answer, but my experience with a lot of the corporate clients that I work with is that it's actually not terribly dissimilar from working with an individual entertainer, in the sense that you still need to have that level of responsiveness and availability to them at all hours, all that kind of stuff. Now, I will say, I've never for a corporate client have I been called, like I have been by a music client on occasion, to come down and take them out of their domestic violence situation, take them to a hotel and pick them up at 1 o'clock at night to deal with their weird home life issues. But corporate clients, especially some of the ones that I work with that have very global presence, they're kind of on the clock. The in-house counsel are on the clock 24/7, and sometimes they need outside counsel on the clock 24/7. So it's not an uncommon phenomenon for me to get emails, sometimes even phone calls at midnight, 2 o'clock in the morning. With it's fairly rare, but it does happen, and I think the value that you really convey and impart to your clients, whether they be individuals, is just the trust and comfort that they can have knowing that you're there for them and have their back. back and will always be for them, and they can totally trust that relationship. And there's nothing that will replace that, you know, if you demonstrate that kind of rapport and that kind of caring, true caring and passion for what they're about and concern for the kind of problems that they're experiencing, they're going to appreciate that and they're going to be loyal clients. Now, it's not to say that you're not going to get any fee pressure. The fee pressure, especially in the last few years, has become a day-to-day phenomenon. And it's something, especially for a firm like mine and for Rhett's as well, you know, it's hard to get larger firms to think outside of the box in terms of alternative fee arrangements sometimes. But the fact of the matter is we're being called upon by clients, large clients in particular, who are sophisticated buyers of legal services, to be constantly thinking about new and different ways to add value and build differently. And so we're constantly, as a firm, reevaluating that and coming up with new ideas, and sometimes those ideas are half-baked, but sometimes they wind up being really solid, and ones that the client can really seize on and appreciate. For some clients who we do a really high volume of work for, we really have gotten pretty good at establishing kind of volume discounts. So basically, the more legal services they're using, the less they're getting charged incrementally on an hourly fee basis. We're also right now working with a couple of different companies on a model that's really more kind of in the mode of being an outside general counsel, so kind of an outside yet inside counsel for companies who are large enough to really require a lot of outside legal services, but aren't quite large enough to necessarily have in-house counsel, but they're kind of right on the verge of needing that. So we're doing things on much more of a kind of routine, flat fee, monthly retainer, that kind of basis. So they don't have to always be thinking about what it's costing them when they call us up and talk to us about an issue. So fee pressures are constant and will remain so in the legal industry.
Add one more. As you use the word value add value, I think that's a good way to manage that is you're doing the same thing that you've always done, and you're going to, every year you increase your rates or whatever it is, the clients are going to push back on that. But if you can figure out a creative way to add value, and it really has to be client specific. How are you adding value for that specific client? Then that's a good way to keep that rapport and to keep that client happy. And an example of this is we have, I was just telling you right before the panel, we agreed to do all of the trademark docketing for a few of our large patent clients. And the intention was never for them to give us this trademark work. But we did all the trademark docketing for them essentially for free, because we won't charge you what we manage the docket.
You may want to explain what trademark docketing is.
Okay, you get a trademark and you file it, and it gets filed in different places around the country, and there are deadlines. And if you miss a deadline, it's over. You lose the trademark, you have to start over. It affects your ability to enforce that trademark. And so we have one client in particular that has thousands of trademarks. Most of them are in other countries, so they didn't have the staff in-house to manage them anymore, and they were tired of paying to have this third-party resource, and third-party resource was missing deadlines, and there was always a scramble. So we decided, okay, well, we'll do this for you. We'll do it for free because you're a great patent client for us, and just kind of an added value, and that has blossomed into us getting a lot of that trademark work, but. For the first few months that we were doing that, it was like this client has this, we would be with them and he would just sound so chipper on the phone, like, this is so great, you guys are helping us out so much. And our paralegals were sending them docketing reminders, such as, hey, there's a trademark that needs to be filed in Chile, and you've got 3 days left before the foreign filing deadline to maintain your protocol and all that stuff. And it was our paralegals that were doing that, and that was the value of that. And that actually then resulted in us getting that trademark work. And so I think that adding value and figuring out creative ways to do that, and that's how you're really going to win over and keep the confidence of the people.
Right, so you're actually creating, like, you're providing the backroom work on a kind of invisible basis for the front. That's exactly right.
How would you guide?
Well, when it comes to adding value, I think it's important when it comes to client maintenance, or one of the reasons why they come to you is hopefully they're at a place where their brand is beginning to blossom. Any lawyer can negotiate a contract. If the client walks in the door and says, I have this contract that I want you to negotiate. That's very easy. It doesn't take a whole lot of creativity to negotiate a contract. The tougher part is when you have a client who's coming to you saying, I'm starting to get some heat just as on a couple different levels. And I really want to build my brand. That's kind of the generic phrase that everybody uses for something they can't really put their finger on, but it's the, you know, the look, the feel, the entity that is that artist. I think with our firm, one of the perks we try to add, and we're in a fairly unique position, but we try to make introductions for that client to key openings that they wouldn't otherwise have access to. It might be on a music client, it might be they're trying to get to a producer, a Pharrell or a Timbaland, something along those lines, and they don't know how to get to that person. We can make those introductions. Obviously, we can't always guarantee that there's going to be a love affair there, but at least we can get them to the right place, because if we don't represent them, we know who does. So it's a mass email away from who manages Timbaland, or any of these entities. When it comes to athletes definitely want to brand themselves. As I said, we don't deal with their sport deals, but we deal with everything else. So they may walk in and say, I want to do more endorsements. How do I have my empire? So taking them to the various corporate entities that we do business with. It might be a record label, because the athlete wants someone on a record label, or it might be a tech company that needs the athlete's name and likeness to add legitimacy to this new tech model. They see these as value adds. They see these openings that they might not otherwise have access to, aside from just doing the contract by contract basis. And then the last part of that is team building. You put a team around them. You put in a good manager, the managers there. You put in a good business manager, the business managers there. Does everybody know what a business manager is? Basically an accountant. But it's an accountant on a higher level. They're the ones that will basically be the CFO of this brand, if you will. That's kind of the idea that I try to convey when I have a client who's coming to me and saying, what can you do? Is I'll sit to the client, I'll say, look, it's like a corporation. You, artist, athlete, whoever you are the chairman or CEO of this corporation. And you need your various officers and departments around you. I'm going to be your business affairs, maybe your business development. You need a CFO, so you need an accountant in there. You need a marketing person, so you're going to need to get out there and get a good PR, a good PR person who's going to be the face of, going to create your persona. And you need a business development person, whether it's an agent or somebody who's out there being pushes for you, finding employment for you. And once you have that team in place, it can act both as an offensive value add. They see this is great, we've got to put this team together, but it also acts as a defensive improvement. That, if you've got the manager in there, you're working with you, you got the accountant in there, everybody is rowing in the same direction. It's going to make it a much more cohesive team, and less likely for those situations where you got the lawyer backstage trying to push it for you. That's on a brand.
I'm curious, just because you hear about it all the time, but how do you manage the conflict of interest situations in these scenarios? If you're the lawyer serving the role of putting the team together, it's inevitable that members of the team are at some point not going to be seeing that eye. Maybe parting ways, maybe it's an agent, maybe it's a manager and the artist. They're going separate ways. They wind up in litigation. If, let's say, hypothetically, it's the manager who brought you in as the lawyer, and all of a sudden now the tussle is between the artist and the manager. How do you, as a lawyer, as a firm, manage the conflicts?
It's Hollywood about conflict.
I've heard that.
It's ugly. It's ugly. There's a lot, to be brutally honest, there's a lot of folks who don't deal with the conflicts. They will, like I said, introduce two clients and then choose the client they want to negotiate for against the other client in some way, shape, or form. You bring up a great point, which is you can't do that. You can't have a conflict of interest, and if you do, it has to be a waivable conflict of interest. So there's every state has its different requirements, but there's certain waiver letters, informed consent, and so forth. The reality is sometimes we do get stuck when we have introduced two clients, and now they've gone off running, and now they have this love affair, and they want to do this deal. We may have precluded ourselves from negotiating that deal for either one of them, in which case we're trying to find a good referral for a lawyer. And that's especially where geographically some of the more independent players, some of the people that are going to be not as like in the thick of things, it's not as much of a threat because they have their own agendas, are going to come up. And so that's when you get your network of friendly lawyers, if you will, people who you respect, who will fight for their clients, but won't screw with you just for the sake of screwing with you. It's an important kind of roster to have, and frankly, it's an important roster to get on if you're just starting out.
Can I just add one thing in the music realm regarding conflicts? Because it's clearly an issue. Every time a rock and roll band or any kind of band walks into your office, there is potential conflict issue. And I'll throw out just two of them that you sort of, and then whenever I do start to talk to a new band, I've always got to be aware of this. You have a situation where somebody's writing all the songs. I mean, let's just take the Beatles as an example. All right, Lennon and McCartney were there. They're writing these great songs. Ringo, not so much. And so they all come in and they go, we want to form a publishing company. And we're going to have one company because that's what Ringo says we should do. Wow, okay, that is a conflict. And it's from moment one. But unfortunately, there's an awkward moment where they don't even have money to pay you, never mind that you going to them going, look, you got a conflict. Everyone should be saying, Ringo, you need your own lawyer, Paul, you should have your own lawyer, and so forth. So it becomes a slippery slope. The other thing, and this happens all the time, if you ever watch Nashville, it happened in Nashville. It happens like every week of the year. And what happens is a band gets together, they're in it for life, they love each other, and then the record label flies in and says, you're the one. The rest of them are no good. We're signing you the deal, and the band is over. Well, I mean, that's a moment in time where that conflict issue can be huge in terms of, well, what's the partnership with the end of the LLC? Who is representing the band? What do they tell the bass player? Who owns the songs? Who owns the masters? Who's getting the recording? Who's not? And so forth. So, these are things that, again, so really, it's a good point. But in the music business, especially just early on, with here are 3 people, 4 people, 5 people walk into your office. The subtle potential conflicts are right there. And I think for a lawyer, it's good to recognize them up front. And if you kind of can sense that there is an inequality to the whole thing, or it's clear that one person is destined for greatness and the rest of them shouldn't quit their day jobs, then you need to probably maybe bow out sooner than later or figure out who you're representing or who you're supposed to represent.
How is it on the corporate side? Are there do you ever see ethical issues when you're dealing with corporate entities and how those come up? And things you kind of have to raise your hand and say, we got a problem? Is there any self-dealing issues, or is there an executive who's also doing the same deal with the company, for instance? Do you ever see those?
I see those with smaller corporate clients. Ones where, it was one guy, we worked with them, and a year later they're pretty successful, and now there's 5 of them, and technically you represent the company, but you're in really well with the founder, and then the founder wants to start doing that, he wants you to do personal agreements with the other members that are part of the executive team. Those are the types of conflicts where the corporation is already established. The types of conflicts we get are more like here's a large patent client. We do lots of patent work for this client. Here we have this small trademark client. the trademark client wants to sue the large bad client, we obviously can't do that. So,
So you're looking for another lawyer to refer to you?
I don't refer to you if you did that. But yeah, I mean, at that point.
But I'll take the money.
At that point in time, we look for referrals, and you're not going to get a referral from me unless I know you personally. And I know that some lawyers don't like that. I just feel like it's such a reputation-based industry, and if I recommend you and you do a disservice to the client, then the client won't trust me. So.
Yeah, that's the importance of joining all the local organizations, wherever you find yourself, being in with those lawyers and being in the mixers with them, having broken bread with them makes such a difference. Just emailing every once in a while, or it doesn't cut it. You really got it. Once you've really had a deal with someone, you've developed a rapport that's not going to be replaceable via digital relationships. I completely concur. As things tighten, as the economy gets worse, and lawyers are looking for you to add more and more value aside from just, hey, cut your fees. How are you seeing the branding? So we've talked a little bit about the branding on the talent side. How are you seeing the branding on the company side? How are they evolving in that sense? And what are they looking for lawyers to do on the branding side? I'm going to throw that on that one.
The most immediate example that comes to mind for me is Columbia Sportswear, which I do effectively almost all of their domestic and some of their international intellectual property work. And one of the recent things that Columbia did to really enhance their brand was design and build and sponsor the Russian, Canadian, and U.S. Olympics teams for the Winter Olympics. And they got a ton of brand awareness and traction out of that undertaking because they designed, not only was the Columbia name on everything that was shown throughout the Olympics, but they spent meaningful time with the athletes themselves and really developed some cool technology with respect to the actual outfits that they were wearing that really helped them. Thankfully, they didn't have an Under Armour speed skating problem. They had a tremendous amount of success. One of the neat pieces of technologies and ideas that Columbia came up with in talking to the mogul skiers, for example, was developing fabric for the pants that actually masked the movement of the legs, because that's what judges dig you on when you're skiing moguls, is how much your legs are actually moving. And the way in which the pants were designed kind of hid that a little bit. And it was a really cool idea. They got, as I said, just a ton of branding traction. And so that's frankly one of the initiatives that I see more and more brands going towards are endorsement deals and sponsorship deals, things of that nature, where the company is sometimes paying an awful lot of money for that, but they're getting an awful lot just in terms of reputational advantage and prestige in return. So that's kind of what I see a lot of companies doing, is kind of pitching their wagons to athletes and movie stars and et cetera.
It's a good question about the endorsement deals. So I think that so much of the industry is going toward that because of the way various products are advertising themselves. So you need to have celebrity linkage, endorsement, it's the word for it. What are some of the considerations when you're coming from, let's start with the corporate side. What are some of the considerations when you're looking at a particular athlete to do a partnership with, an endorsement deal with? What are the things that the corporations are going to want? What are the critical points? Not dollars and cents necessarily, but...
Well, they're, number one, going to be pretty cognizant of the individual's reputation state and whether or not they think they're going to be a good representative of the brand overall. One of the kind of hot button areas that you always get into, and almost always get into in endorsement and sponsorship arrangements, is kind of a morals clause. And what's the morals clause going to provide, and how bad does the activity have to be before the sponsor has an out and the right to terminate the agreement? So you want to, be thinking about those kind of issues if you're the company, and make sure that you're kind of got a pretty good understanding of the integrity and character of the person that you're going to be pitching your brand name to make sure that that brand name doesn't wind up getting sullied by some bad action that the individual might engage in. The other kind of issues that a company is always going to be wanting to keep their eye on is making sure that the celebrity, the athlete, whatever it is, it's really clearly outlined in the agreement what the expectations that you have of that individual are. That can be anything ranging from, are they always going to wear a shirt with our logo on it when they're in certain situations? Are they going to agree to make a certain amount of personal appearances for us every year? How long are those personal appearances going to be? What are they going to be comprised of? The more clarity you can have in the agreement about what the mutual expectations of the parties are, the better off you're going to be. I've seen a lot of pseudo endorsement kind of sponsorship deals for admittedly lesser known celebrities and athletes. Kind of try to boil it down to a page or two, and that's awfully hard to do no matter everyone's best intentions. Sometimes it just takes a little bit of ink to spell out exactly what the parties expect from one another. So that's an important consideration. The other thing that we always think about when we're doing deals with Columbia, for example, not only do they sponsor skiers and things of that nature, but their Mountain Hardwear subsidiary sponsors a lot of kind of extreme winter athletic type folks, extreme climbers, extreme skiers, really perilous, dangerous activity. And so from Columbia's perspective, what we're looking at there is we want to make sure we've got clauses in there that basically specifically say, hey, we're not forcing you to do any of these crazy activities that you're going to do. You're doing this of your own volition, and if you get hurt, if God forbid you get killed doing it, it's not our problem, it's not our responsibility, and you and your heirs agree that you're never going to sue us for it. So it's those kind of issues that you're thinking about in those contexts.
And from a talent perspective, that same situation, like what comes to mind when your clients are approached with the corresponding deal?
Well, I just want there's low-end deals, there's high-end deals, and oftentimes you get the low-end deals first. And the low-end deals is the drummer who uses a certain kind of symbol, and it's like, you like those symbols? We'll give them to you for free, sign this contract. So they email it to you, you've got like 10 minutes to respond, back to responding quickly to clients. Here, there's no money at stake, it's free symbols, but lo and behold, they can't be on stage with any other symbol for some crazy period of time. So what you do is you do enough of those little sort of run-of-the-mill, we'll give you 5 microphones if you sign this piece of paper deals to a deal with Coke or Pepsi or Dr. Pepper or whomever. And in all of those, to me, for the heart of it, for the artist, is the exclusivity clause in terms of it's like, well, what are you agreeing that you won't do in the future and for how long, and how's that going to impact on what you do? I mean, if you do a deal with Nike today, can you walk on stage with a pair of, say, Keen sandals, or is the agreement such that you can never wear another pair of shoes other than Nike ever again, or not appear in public ever again with another pair of shoes? And how far does it go? And does it go to the other brands? Are we now into the clothing business? Is this deal that we did with Nike in exchange for X dollars and X numbers of shoes, does it preclude wearing a Gap t-shirt or doing a deal with Gap and so forth? So ultimately, making sure that they don't just take the money at the short run, kind of going, hey, this is great, this is a great relationship with a cool company, and lo and behold, stuck in the back of the contract and this exclusivity clause, it comes back and haunts them 6 months or potentially years later.
Yeah, along those lines, another thing that I've experienced in a bad way, not malpractice way, but I've commented walking the door with a contract that allows is what they call the flow-through runs, which allows, they do a deal, say, with a Nike, allows Nike to do a Chase MasterCard and use their name or their picture on the car, or do a co-promotion where they're going to have a special giveaway of a particular product they might be endorsing at Burger King. And suddenly, your client is magically endorsing Burger King with no additional compensation. So the scope of what they can use your client's contributions for, whether it's a name and likeness deal or some other kind of creative contributions that your client may be creating. The scope has to be finely negotiated so that you know exactly how far out it's going to go and what other types of brands and co-brands are going to receive a benefit from your client's assets. I find it's always a critical point. I should think, right, that like when you have endorsement deals, which also have elements where they're approaching, say, the town, the corporation may be approaching the town saying, we want to launch an apparel line, and we want you to design the apparel. We want you to be involved in the designing of this particular shirt or shoe or whatever it happens to be. And we're going to use your name, and it's going to be a Air Jordan type brand. How do you deal with the intellectual property issues there that come to pass?
You know, I think it's a very timely question because it's so applicable. The intellectual property is kind of becoming that's the very first thing that you talk about, other than maybe some other fundamentals like units or how much someone's going to do data or whatever. Essentially, we just say right off the bat, it's better to get it in the contract and have it clear who's doing what right away than to do that preventative legal work so that in a year or something, 2 years, whatever the time frame is, that there's not an issue. It's just clarity. It's just, basic, fundamental corporate contract line. That is, who owns what, under what circumstances, and when. And you need to have a corporate attorney in there and a corporate litigation attorney, all kind of looking at it, saying what are the possible pitfalls. And that's kind of the way that I like to do it. Even when I would have my own small practice, I associated with each of those types of people. And so that we could issue one together and we could work together as a team to do the preventative legal. And for the corporate clients that can afford that, it becomes a great add value. I'm curious how you guys do that for the corporate or for your clients that they can't. They don't necessarily have the funds to afford a team to issue stuff. But maybe Mike wants to add
Well, the other thing I was going to say was, oftentimes in apparel-oriented celebrity endorsement deals, sometimes the celebrity themselves are asked as part of the arrangement to participate in the design of the new product, whether it be a shoe or the US Olympic team. Those athletes were involved in coming up with the ideas for the apparel. So, who's going to be owning those rights? And those rights can be patent rights, they can be copyright rights, they can be simply name and likeness rights. There's all sorts of intellectual property rights floating around, and it's critical to have clearly outlined in the agreement what the IP allocation and ownership is going to be. Obviously, from the corporation's perspective, you want to own everything. From the artist rep's perspective, you're going to try to carve out a piece of that action to the extent you can. And that's frankly, in some of those deals where those aspects are part of it, where the celebrity is participating in product development, that can be a real hot area of negotiation in those deals. It's kind of part of the fun part.
I think just one quick little point, and that is that ownership plays directly on enforceability. And so oftentimes when ownership isn't carved out, and you get a situation where you might have an individual or companies who thinks that they have the intellectual property rights and the right to enforce when they don't. And then you have this issue where they're saying, well, I'm the one that wants to enforce this, and typically the corporation says, no, look at this clause that says right here you cannot enforce that. And so that should be clear as well. But anyway, I'm curious.
And I was just going to say, from my perspective, representing the artist, I'm wary. To me, the lights go on, the flashing warning lights go on whenever it's, hey, design a clothing line. Because my concern is now there's more things that can go wrong. And just thinking about contracts, it's so much better to have a finished record than it is to be talking about making a record. Because between point A, between the idea and the reality falls the shadow, as someone would say. And it so happens in contracts. And the idea also that you're taking someone who's great at making music, great at writing songs, great at making records, they may not necessarily be great in the world of designing clothes. And history has shown that when entertainers and certain, some can do it if you can truly cross these lines. But with that, I think it's fraught with risk. And just as the contract lawyer and also as the transactional lawyer, I'm going to try to dissuade my client from doing that if I can, or at least throw out the idea that maybe this is not the best use of your time, and this is maybe fraught with a lot more peril than meets the eye.
And one other aspect that I want to add to that, and I think it really applies in both instances, both from the corporate perspective as well as from the individual perspective, is the due diligence elements. That, and this comes with almost any contract your client ever proposes to sign, which is you have to know what came before. Are there any contracts out there that your client is bound to that's going to put them in violation of the new contract? And most clients walk in the door, whether they be corporate or towns, especially towns, with no summary of the deals that they're bound to, no status of how long each deal goes. They just come and they say, I got this deal from Red Bull, and would you please negotiate it? If we can get the fees, I want to do the deal. He said, it's great, okay, let's do the deal. Well, but maybe they have a deal with Monster that's going to put them in violation of the deal. And I can't tell you how many times that phone call or that letter, usually it's the enjoy your weekend letter. It's the weekend. It's the letter you get like around 6:30 on Friday night. Saying we represent fill in the blanks, cease and desist. Those can be critical, and you don't want to be in a position of having to say, "Well, it's not my fault. How was I supposed to do?" You should be asking the question: are there any deals that we should be aware of that we have to address? That's my thinking. Okay, we want to open it up for questions?
Yeah.
Did anybody have any final thoughts on that before we open it up for questions?
So we have 5 or 10 minutes for questions if anybody has them.
Short of acting as a human bodyguard, how do you deal with some of the politics once another lawyer has approached your client, and how much of that is just trusting your relationship with your client, and how much of that is like, maybe I'll send a strongly worded email to that attorney?
I don't know that it's ever a great idea to send a strongly worded email concerning that subject matter, because it's the kind of thing that will get forwarded directly to your client. And see, your lawyer's trying to block you from having options. So there's almost no upside in doing that. When we have those problems, and we all have those issues where we're hearing on the street that so-and-so is, the lawyer's making a move. The best thing to do is kind of what Ed said, which is make sure that client feels you, knows you're there for them. That's the time where you say, let's bring you into the office, let's spend some quality time together, and let them feel you again. I would never confront the lawyer himself or herself if they were doing that, not generally, unless I was like friends with them saying, really? But generally it would be considered.
Yeah, I mean, we're lawyers, they can fire us at any point in time, and then the question just becomes, well, what happens to the compensation? We didn't talk about how we get paid for this, and sometimes we do, and sometimes we don't. But if we do, it's either hourly or it's a percentage. So what is, the more awkward situation is you work with somebody for 2 years, you haven't made a dime, and lo and behold, they suddenly hit the big time, and then the big time lawyer comes in and goes for the client. And so what happens to your 5%? Do you have 5% under that scenario? But I think, you would, clearly the client has the right to go to this other lawyer, they always do. And so I think hopefully you've covered your bases before then in terms of some relationship and a retainer agreement and or contingency agreement.
Although I would also add, if you have that team of individuals around you and say you're close with the manager or the business manager, I would typically call one of those guys and say, I'm hearing that the client's taking a meeting, or that so-and-so is trying to track him down. You know, can you check that out for me? Which is code word for, can you play, you know, interference for me?
Any other questions?
I'll just tack on to that just for a second before we go to another question. I think in this day and age, you have to always, especially if you're representing somebody as high profile as Guy and Ed do, you have to always assume that somebody else is going for your client. So you just have to operate and behave that way and do the absolute best job and make sure that that client has that level of trust for you and that you've sufficiently conveyed to them the value that you bring to the relationship.
Just to go off of the Red Bull Monster type of situation, are there any other research tools that are available if your client doesn't recall that they have a Monster deal already in place?
Well, you can look public company SEC filings. You know, they oftentimes have to file redacted copies. You know, you mentioned the dollar figures, but redacted copies of license agreements that they have in place. But you know, frankly, if you're representing the artist who's coming to you, you'll need to do some internet searching and see if you can figure out whether there's a tie that's been linked to the artist in the past, and if so, you may have to actually reach out to the company and say, you know what, just can't find a copy of that thing, can you send us
I mean, other resources would be, if they do have a former attorney, you're supposed to, you know, send a letter and ask for the files. Different states have different rules about who actually owns the files. In California, the client owns the files, so prior lawyers have to ship everything to the new lawyer. In New York, that's not the case. They can kind of sit on the files and just send the key documents. But either way, that's going to be like the first of the check boxes, which is, have you asked for the prior files from the prior lawyer? Because if you don't and you do a deal, then you really could be in trouble if you didn't even bother to inquire for the files.
It's a whole other can of worms if the former lawyer hasn't been paid.
We probably have time for one more question, if anybody has one.
I was wondering, how have you guys adapted to like new media coming online, like social media, intellectual property rights issues that exist with artists posting stuff themselves, maybe companies as well?
That was probably the issue of the era right now, social media and online. I gave a presentation this exact same day last year called Current Trends in Online Brand Protection. And that's like a whole day workshop. And it depends what country are you talking about. Is it a trademark? Is it copyright? Is it stuff that will eventually be imported? Is it being done using new technologies like Bitcoin? And who's the company that you're dealing with? Because Facebook has a different IP policy than Amazon, has a different IP policy than eBay, and it has a different IP policy than Twitter, that has a different IP policy than Pinterest. And each one of those creates a different type of scenario. And really, it's just, all of these things are happening. And I think it's across the board for corporate or for individual clients. It's like a total nightmare. And you feel like you're in damage control all the time. And I do feel like that's an area that's a little bit wild west. Because, especially when you're dealing with countries outside the United States, they don't have the same type of feelings about intellectual property as the United States does. And so if you send an equivalent of things you take down to Sweden, they would say, no, you can't. In Canada, they just say, no, are you crazy? Are you out of your mind? Do that. So that's a great question. And there are things that we can do, but I think that we need to talk to the app about, you can drive home with me for 5 hours, and I'll tell you that.
I mentioned that I represent a wrestling league, and it gives the wrestling league fits about that because wrestling, don't tell me but wrestling's fake. And so they had a certain creative storyline that they're pursuing, and then they got their talent out there tweeting do that, so it's very difficult to manage that.
Yeah, I mean, just the whole social media clause in any kind of branding or endorsement agreement becomes really significant. And there's this whole, who drafts this, how many tweets are there and what social media platforms are we talking about? Is it Twitter, is it Facebook, is it the website and so forth? How deep does that go? How many, who does the initial draft? Who approves it? What's the approval process? Can they be unreasonable in the denial of approval, and what happens then? So it's this whole new element. And then just one other thing, you're talking about new technology. The new technology thing, it used to be a band would go play Bonnaroo, and then it would be a live performance engagement with a rider, and it's what kind of beer and pizza do they want backstage, and what technical specifications. Well, now it becomes a deal where they want to stream it, and they would like to do video on demand, so it's complicated with some record deals, or more complicated with some record deals to play a show, because every promoter wants these ancillary rights if they can get them. And so the day before the show, or sometimes an hour before the show, in comes this contract that says, oh, and by the way, we've got a camera crew here, we're videotaping this, we're doing a live stream, we want to do an archive stream, we want to sell it for download, and now you've got a whole what was once play a show becomes a whole new deal because of competing.
Let's go ahead and give our panelists a round of applause.